The president continues to be dogged by the Stormy Daniels scandal. On Tuesday, the adult film star, whose real name is Stephanie Clifford, sued the president. She wants a court to give her permission to tell her story, the same story for which she accepted $130,000 to remain silent. Her lawyer has appeared all over this week, but as an attorney myself, I think there are still a few questions remaining to be answered by Michael Avenatti. Counselor, thank you so much for being here.
Thanks for having me, Michael. Good morning.
So Michael Cohen has been hammered all week long, I think, in connection with this litigation and this particular episode. I have to say, as an attorney who has settled many cases for amounts that include a lot more zeros than this one, I found the paperwork surrounding the settlement to be pretty sophisticated.
Well, Michael, quite honestly, I don't agree. I mean, I think on its face it's sophisticated, but this was not handled appropriately based on my experience. I mean, this was not buttoned up properly, starting with the missing signature of his client, Mr. Trump.
But I think it was not buttoned up because perhaps of the representation. You didn't provide it, your predecessor did, but the representation that was afforded to your client.
Well, no, it wasn't the representation afforded to my client that required Mr. Trump to sign it. I mean, that was Mr. Cohen's job, and Mr. Trump didn't sign it. And under California law, and that's what this is going to be decided under California law, we are highly confident the contract, the NDA, is going to be thrown out. And more importantly, there's an express provision. I've watched a lot of legal pundits that are opining on this document and its enforceability, and unfortunately, a lot of people aren't actually reading the document before they appear on television.
I agree.
And that's that's a real problem.
Okay.
You know, and I know, you got to actually read the document.
All right. So listen, look at my copy. I've
You've
read
the
it.
document.
It's all tab.
Excellent.
Let's go through it. Let's go to the signature page to begin with. This is at the tail end, and folks can there see David Dennison's line, AKA, presumably it would have been filled in Donald Trump, not signed. And you believe, Counselor, it's because he did not sign it that the whole document should be held null and void. True?
Absolutely.
Okay, so now let me take you to the settlement agreement, paragraph 1.1 that identifies the parties, because I noted something and I've circled it on the screen. The settlement agreement and mutual release, yada, 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 by and between EC LLC and or David Dennison, DD. Doesn't the and or mean that EC was capable in and of itself as resolving and settling this action? Why else would there be an and or clause?
No, because and or is a term of art in the legal profession, and under California law, it is found to be a plural use of the term. It is in the conjunctive. And furthermore, if you look at paragraph 8.6 of the agreement, it specifies if the agreement is not signed by all parties, it's invalid.
Okay, therefore, I come back to where I back to where I began, which is, shouldn't she refused to have taken the $130K until there was full execution?
Well, I mean, that certainly was an option. That's not what happened. And so we look at where we stand now, and where we stand now is that we've got an agreement that was never signed by all parties, which is required under California law and expressly required under paragraph 8.6 of the agreement. We are highly confident that this agreement is going to be tossed out, and if it's tossed out, she's prepared to return the money.
I don't want people's eyes to glaze over, but to me it seems like the question is one you and I learned on the first day of contracts: offer, acceptance, consideration. I think you have all three. Let me show you something. Go to exhibit number 3. Each page of this agreement needed to be initialed. And on the initials line, I'm putting it up on the screen, instead of David Dennison, it's EC, which is that other entity that was created by Michael Cohen, presumably to settle this case. In other words, all throughout the document, EC signed, not David Dennison, I think by virtue of that language that said it could be either of them, and or.
Well, I disagree, and we're going to have the court decide, but I want to address something you just said. Offer, acceptance, consideration. There was no acceptance by DD of this agreement. He never signed it. Furthermore, where's the consideration from DD? The agreement, and as you know, there has to be consideration from DD. Everybody talks about the $130,000, Michael, but you know, based on your detailed review of the agreement and the tabs that you have on the side of the page, you know that my client bargained for not just money. My client bargained for other consideration from Mr. Trump. It's in the document that he was required to provide, and by not signing it, my client did not get the benefit of the bargain.
Let me talk to you about the arbitration process, which I know you think was bogus. I note that the notice, 8.8, the notice provision, the service provision, required email or facsimile and telephone of your predecessor, Keith Davidson. Was Keith Davidson notified in advance of the arbitration?
Not that we're aware of, but it's simpler than that. Mr. Cohen EC could not proceed with the arbitration. It required only DD. If you look at who was able to get a temporary restraining order, Mr. Cohen nor EC had standing or the right to do that pursuant to the express terms of the agreement. Only DD, only Mr. Trump. And we believe that the reason why they didn't have Mr. Trump proceed in arbitration is because they wanted to continue to keep this quiet and continue to basically hide his involvement.
Okay, another question based on the documents. Put up Exhibit 4 if we may. This is 3.1C. And there's a lot of language, Mr. Avenatti, throughout the agreement about this. Here's what it essentially says. It essentially says your client needs to return to DD, let's just say it, President Trump, all evidence relative to what went on here. And that includes email messages, text messages, Instagram messages, Facebook posting, or any other type of creation. Question, did Stormy Daniels hand over whatever evidence she's got of this liaison?
I'm not going to answer that question, but here's what I'm going to say. Mr. Trump and Mr. Cohen and others better be very, very careful relating to statements publicly as to whether this actually happened or not. That is what I'm going to say.
But she had a contractual obligation to hand over whatever she was in possession of before she took the $130K.
And I didn't say that she didn't, and I didn't say that she did. What I've said is I'm not going to answer the question.
Okay, one other question, if I might. There's another paragraph. I don't think I blew it up, but 5.11, disgorgement. What this essentially says is that if she violates it, she owes $1 million for every episode that she goes out and speaks in violation of the confidentiality. It occurs to me that Michael Cohen may have made a wise business decision. Everybody's laughing about him giving her $130K if it came from him, but he'll get a tenfold return on that money if in fact she speaks and violates this agreement. That's not a bad return.
Michael, you know, based on your experience, that term, even if everyone agreed to it, it is so unconscionable, meaning it is so beyond the pale that there is not a court that would enforce that at that level with $130,000 at the front end and $1 million liquidated damage clause per instance. No court in California is going to ever enforce that.
Okay, if that's the case, then why doesn't she come on a program like mine right now and tell whatever the story is that she's dying to tell?
Well, I think we may see that. I think we may see her provide a very detailed explanation of what happened. She's going to discuss what happened, let Mr. Trump come forward and provide his version of events, and let the American people decide who's shooting straight with them and who's covering things up.
Has anyone, including Larry Flint, but I want to ask this in a universal sense, has anyone offered to pony up the $1 million to protect her and say, here, I'm good for it, go tell your story?
At least 10 individuals in the last 3 days alone.
10 individuals in the last 3 days alone. Are any of them Larry Flint?
No, not that I know of.
Is she contemplating taking any of those 10 offers?
No.
Does she think in retrospect that $130K was chump change because after all he was elected president? I'm really asking whether that amount was determined by her perhaps believing the polls a week out from the election. Hey, he's not going to win anyway, I may as well take the money.
No, I think when and if she's able to tell her story, the American people are going to learn how that amount was arrived at among the parties. But This isn't about her having buyer's remorse. It really isn't.
Okay, final question. I'm just intrigued. Peggy Peterson. How do you come up with Peggy Peterson? How do you come up with David Dennison?
Well, you're going to have to ask Mr. Cohen because he's the one that came up with these aliases. So we have no idea.